High Court in Meru.
Yes.
It is perfectly open for you, my lord, to interrogate the pleadings that have been filed by parties, the submissions by the parties, and for you, my lord, to arrive at your own independent decision as to the question of whether there was a conservatory order. It is a live matter that is before you, my lord, and we will urge you to exercise your discretion on that question.
When your time is reached, we will submit on that with more breath.
Thank you, my lord.
You may proceed.
Thank you. Just one comment so that the record and capture that. Mr. Kawira says that the petitioner came here and didn't disclose to this court that there was a pending contempt of court application at Meru. The farthest an advocate can go from the truth is that submission, the farthest, because the petitioner, in fact, attached the full contempt of court application in Meru as an annexure to the filings here. How clear can a disclosure get, my lord? I have been at the bar for the last 20 years. I can't imagine a clearer disclosure than actually photocopying the full contempt of court application and putting it before you as one of the annexures. And more importantly for me...
No, that's not how I do things. Let counsel finish his point.
I'm guided.
Yes, counsel Mwangaza.
Just for completeness of record, that application is to be found in volume number 9 of the documents before you at page number 64. At page number 64 onwards. Order number 2 is that the Speaker of the County Assembly of Meru, I. Bundi Solomon, the Clerk, Meru County Assembly, Jacob Kirari, and Zipporah Kenya, a nominated member, the condemned be cited for contempt of the orders of this court issued on 24th and 29th July 2024 by Justice Linus P. Kassan. It doesn't get clearer than that. Allow me to progress.
Just a moment, Councilor Ngoya. Yes, there's an interjection.
My lord, the interjection is the issue that the petitioner did not disclose is that the question of the conservatory order was pending in another court. It's not a question of content. It's the issue of whether the High Court in Meru and this court, there is a possibility of these two courts arriving at conflicting decisions on the issue of the conservatory order. That is the issue. It's not the issue of content.
Well, let me progress so that there's order.
Just a moment. Your time is not running.
Thank you.
So I will... this is an important link because there are certain consequences to the High Court making a finding of contempt, rather allowing a contempt application. Those facts, the factual basis that led to that decision would then be res judicata. That is the uncontrovertible position. The High Court cannot speak on the same facts, same law, same circumstances twice. That is not open to us. So what I will invite those opposed, I will add a little bit more time so that you're able to canvass that point. Because I do not want, when I retire, for myself to call you back for us to have that discussion. So we will have it extensive as to what is the application and import of that recently delivered ruling. You will appreciate, counsel, that it was delivered just about a week ago, so I could not call you or ask you to comment on it or to file supplementary submissions on it. So we'll have to do that today. Councillor Ngoya, your time is back on.
Thank you, Madam. Before I progress, I noticed that when we took the quorum, the counsel for the second interested party was not present.
Yes.
Like I said, my learned colleague Eunice Lumala is present. It's only good perhaps that I put her on the record formally.
Thank you, Council.
Good afternoon, Council. How are you?
I'm fine, thank you.
It's not good afternoon. Good morning.
Yeah, and apologies for coming in late. I was before an arbitral tribunal. Thank you.
Thank you. Yes, Councillor Ngoya.
Thank you, my lord. I had already agreed to court that paragraphs 33 to paragraph 40 of that ruling, which is at pages 115 to 118 of volume number 10, are crucial. But I'll read them without asking the court to record that verbatim because the record is before the court. And this is what your brother, Justice Moreidi, observes.
Yeah.
The court orders as issued on 24th July 2024 were clear, halting in any way the impeachment process against the petitioner pending the court's delivery of its substantive ruling. However, the respondents on 30th July 2024 proceeded to withdraw the previous impeachment motion and pave way for the introduction of a fresh impeachment motion. However, the orders as issued on 24th July 2024 were still in existence and had not been vacated by the court on application by either party to the suit. The respondent acted in contempt of court by seeking to reintroduce a new motion of impeachment against the applicant. It is the old lesson in Hodgson's case, Hodgson versus Hodgson, Volume 2, 1952, All England Law Reports at page 567, where Justices Somerville, Denning, and Roma taught yet again to obey all extant orders of court. Held by Somerville and Roma Lord Justices that it was the unqualified obligation of every person against or in respect of whom an order had been made by a court of competent jurisdiction to obey it unless and until the order was discharged. I draw my court's attention to your brothers highlighting and underlining to add emphasis to the words unqualified and the words to obey it unless and until the order was discharged. Most unfortunately, the rule of law is still under threat close to a century later. Your brother has just made a finding that the County Assembly of Meru is a threat to the rule of law almost a century after the finding of Lord Justices Somerville.
Let's circle back.
Yes, my Lord.
Let's circle back. I think it is the preceding paragraph.
Yes.
A large part of the defense by the respondent and also by the County Assembly is that the initial order applied to an initial motion.